Hello everyone, this is the video of Legal Studies, Class 12, Unit 1st and topic that is Appointments, Retirement and Removal of Judges of High Courts. So in this video, I will be discussing everything about the Judges of High Courts. In previous video, we have discussed about the Judges of Supreme Court. So now let's begin with the appointments of Judges of High Courts. Clause 1 of Article 217 of the Constitution describes the provisions and methods of appointment of judges of the High Courts of India. So, it is a constitutional body because it is defined in the Constitution of India. Further, it says, as per this provision, every judge of the High Courts shall be appointed by the President after the consultation with Chief Justice of India, the Governor of the respective state, and in the case of appointment of a judge other than the Chief Justice of the High Court. So this provision you need to understand because there are certain points that defined in this provision. The first thing that's saying that if a Chief Justice of a High Court need to be appointed, then the President will consult the Chief Justice of India and the Governor of that particular state. The another point that this provision is saying, that is the other than Chief Justice means the other judges of the High Court. So in that condition, one person more will be added. So now President will consult the Chief Justice of India, the first one, the second one the Governor of that state, and the third one that is the Chief Justice of that state. For example, there is vacancy in Telangana High Court. Then the President will consult the Chief Justice of India, the Governor of Telangana state, and the Chief Justice of Telangana High Court. So these three persons will be consulted by the President to appoint the judge of the Telangana High Court. Okay, now let's check out the other provision, that is qualification and eligibility of the judge of the High Court. Clause 2 of Article 217 of the Constitution defines the qualification and eligibility to be appointed as the judge of the High Courts as must be the citizen of India, has for at least 10 years held a judicial office in the territory of India. So this point is saying that he must be serving as a judicial person. He may be a judge in the district court or may some other judicial officer, and he has to have the 10 years of experience minimum. Or if that fellow is not having this qualification, then the another qualification he should have, that is has been for at least 10 years an advocate of a high court or of 2 or more such courts in succession. So a practicing lawyer who has 10 years of experience in practicing in a high court or such high courts in succession means in continuity, there shouldn't be break. So he is also eligible for the judge of a high court. So any one of them a candidate has to have. But here I would like to take your attention, that is, if any question arises as to the age of a judge of a high court, the question shall be decided by the President after consultation with the Chief Justice of India, and the decision of the President shall be final. So President is a deciding body in case of any discrepancy regarding the age of the candidate. Now check out the other provision, that is methods of appointment. Whenever a permanent vacancy is expected to arise in the office of a judge of the respective high court, the Chief Justice of the same high court will, as early as possible, but at least 6 months before the date of occurrence of the vacancy, communicate to the Chief Minister of the state his views as to the persons to be selected for appointment. So, this provision is simply saying that if there is a permanent vacancy expected in the court, then Chief Justice of that High Court will first consult the Chief Minister of that state at least 6 months in advance, so that the procedure of the appointment of a judge can be done before the retirement of that judge, so that his position can be filled on time. One point more that you also need to understand, that the view of the Chief Minister is also important. It's not only the procedure that need to be followed, but Chief Minister can also share his views and he can advise to the Chief Justice regarding the candidate. The next provision is methods of appointment. That is, as per clause 1, article 217, every judge of a high court shall be appointed by the President by warrant under his hand and seal after consultation with the Chief Justice of India, the Governor of the state, and in the case of appointment of a judge other than the Chief Justice of the High Court. We have already discussed this point in my previous slide. So, I believe you must understood this point. Now, check out another provision, that is oath or affirmation. As per Article 219 of the Constitution, every person appointed to be a judge of a high court shall, before he enters upon his office, make and subscribe before the Governor of the state or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. So, this provision is saying that a judge of a high court will take his oath or affirmation in the presence of governor of that state. And this provision is defined under Schedule 3 and Article 219. Now check out another important provision, that is the tenure of the High Court's judges. As we have seen in my previous video that the judges of the Supreme Court have no fixed tenure. They retire at the age of 65. Similarly, the judges of the High Court have no fixed tenure, rather they retire at the age of 62. And the Chief Justice of High Court also retires at the same age, that is 62. Now, let's discuss another important provision, that is the salary of the judges of the High Courts. Article 221 of the Indian Constitution leaves it to the Indian Parliament to determine the salary, other allowances, leave of absence, pension, etc. of the High Court judges. So, it is the Parliament who has given the power to decide the salary and other allowances of the judges of the High Court. Again, we have seen that in case of the Supreme Court, Parliament who decides. Similarly, in case of the judges of the High Courts, it is the Parliament who decides. So, now let's check out what is the salary that a judge of the High Court draws. A judge of a High Court draws a salary of 225,000 rupees per month, while the Chief Justice of a High Court earns 250,000 per month. Now, we have the last provision, that is the removal of judges of the High Court. So, what are the procedure that is followed to remove a judge of the High Court? As per the constitutional provision, a judge can be removed only by an order of the President based on the removal motion passed by both the Houses of Parliament separately. So the processes of the removal of the judges of the High Court are literally same as of the judges of the Supreme Court. A judge of either High Court or Supreme Court can be removed from his or her office through a motion adopted by Parliament on grounds of proven misbehavior or incapacity. However, if you want to check out this provision in detail, you can check out my previous video, that is the removal of the judges of the Supreme Court, because the procedure are same. So this is all for this video. See you in next video.